The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
I'm Ted Rowlands in for Vinnie Politan. The subject of our investigation is the case against Karen Reed, this time playing out in civil court, as the family of John O'Keefe has turned their attention now to a different arena. Here's the story. She celebrated the victory, but another battle looms ahead for Karen Reed. She and her attorneys were emotional after her second trial when a jury acquitted her in the death of her boyfriend, Boston police officer John O'Keefe, culminating a years-long public saga that sparked support across the nation for an accused killer.
Love you. Free Karen Reed! Free Karen Reed! Free Karen Reed!
The prosecution presented mountains of evidence trying to prove that Reed drunkenly backed her SUV into O'Keefe and killed him outside of a party in 2022. We saw statements from first responders, surveillance images, intricate taillight forensic analysis, hotly contested GPS data, and statements from the defendant herself. The defense raised questions about all of it and poked holes in the investigation, questioning the actions of investigators and raising alternate theories of what caused John O'Keefe's tragic death. Now, O'Keefe's family has brought the case back into a Massachusetts courtroom, filing a civil lawsuit against Karen Reed and the two bars where she drank with John O'Keefe earlier that night. So what is the basis of this civil lawsuit? A guy by the name of Mark Diller is one of the attorneys that's representing the O'Keefe family. And during the first pre-trial motions hearing, he basically, in front of the judge and everybody in a packed courtroom, laid out the case.
Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost two parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost two parents from January 29th forward, Your Honor. Karen Reed plots. She fabricates a conspiracy. She launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seen before? To the extent that the defendant argues that this is not extreme, and outrageous? Remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was the defendant's conduct extremely outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. What Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor.
Okay, let's get to our first question in this investigation, and that is, how strong is the O'Keefe's case going into this civil litigation? Let's bring in our experts to help us out here with that question. Margaret McLean is a former prosecutor and the host of It's a Crime with Margaret.
No idea what she said.
And there's Wayne Dennison, trial attorney. He's up in Massachusetts. Good evening to both of you. Margaret, first blush here, what's your take on the strength of the case after that first hearing that took place?
Well, first of all, on a whole, this case is much stronger than the prosecution's criminal trial against her. So remember, in a civil wrongful death case against Karen Reed, the plaintiffs, which is the O'Keefe family, will have a much lower burden of proof than in the criminal trial, which was proof beyond a reasonable doubt. So the plaintiffs only need to prove their case by a preponderance of the evidence, which is more likely than not, and that's a 51% standard. And that means jurors evaluate the evidence. The plaintiffs only have to prove that there's a 50% chance that Reed caused O'Keefe's death. So you also here have a different venue. Remember, it's Plymouth County and not Norfolk County, which I think is a little less sympathetic to Karen Reed. So as a whole, it is a much stronger case for the plaintiffs.
Wayne, do you agree with that?
Far be it for me to disagree with Margaret on anything. I do believe that it's an easier case to prove. It's an easier case to prove largely because of the very different standard of proof. And Margaret's absolutely correct. 51% gets you over the bar. It's today's hearing was all about whether there were claims for a negligent infliction of emotional distress that ought to be dismissed before they go forward for discovery. It would surprise me to see the judge dismiss those claims. And this is going to be a case subject to very wide-ranging discovery, and discovery that's going to include the deposition of Karen Reed. And so I do think that we're looking at a very different animal going forward.
And a very drawn-out process, as civil cases are typically. I mean, criminal cases are drawn out, but this is a different level. The discovery deadline set tentatively by the judges end of December of next year, not this year, of next year, and then a trial date possibly in 27. And Margaret, during that first hearing, we gotta look at the army of attorneys that both sides have come in with. Karen Reed has Alan Jackson at her side again, and it's just one after another was introducing themselves to the court after, for this first preliminary, first motions hearing, and you really got the sense of, oh boy, is this gonna be another battle royale like we saw in the criminal trial where it was personal, and both sides seem to have walked into that courtroom with that same mentality. What's your take in terms of this thing and how nasty it might get?
Well, I've never seen so many attorneys in a civil case before like that. I mean, I've defended, I worked in civil defense, and I've never seen so many attorneys. And I do think, though, if you notice, the judge was talking about, he was almost talking like a mediator would at one point. And he said, you know, we have to get together, the different sides, and talk about it. So you've got the attorneys for the bar, the multiple attorneys for Karen Read. There's actually 2 bars. So I'm thinking that along the way, some of these parties will likely settle, so we'll have a few less attorneys, and maybe the case can settle as a whole. You never know, because there are insurance companies behind, you know, the different bars and Karen Read. So, you know, it's all about dollars and cents here.
Yeah, there are 3 defendants here. You have the 2 bars where Karen and John were drinking before his demise, and then Karen Read herself, and we'll see all of that play out with the 3 different. And you're right, the judge basically said, hey, if you want to take some advice, I've been around a long time, getting together might be a good idea, because this is going to be drawn out, and we'll see. Let's get a break. Stand by, guys. Coming up next, we'll talk about the other side. How strong is Karen Read's case? Stay with us.
None of the plaintiffs observed the alleged incident that is described in the complaint.
The Court TV podcast will return.
Murder in the 2nd degree. What say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
Defendant not guilty or guilty? So say you, Mr. Foreman? So say you all? Jurors, hearken.
What a scene that was. It was all cheers after Karen Read was found not guilty in her 2nd criminal trial. But she'll be going back into a Massachusetts courtroom for some time to come, because the O'Keefe family has filed civil litigation against her. During the first pretrial motions hearing, we got a sense of both sides. We got a sense of the O'Keefe family's suit against Karen Read and the 2 establishments that basically provided the liquor that they drank. They're 2 bars. They're involved in all of this too. We also get a side from how vigorous Karen Read is going to fight this. And we got it from one of her attorneys. Well, Alan Jackson was there, but he was not speaking today. Damon Seligson did the honors. Here's a bit of what he had to say in court during that first hearing.
None of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is no... The cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Katie Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress, and the basis of that claim is that there was a discussion on the telephone, or discussion after Karen Read had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Katie Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative, and allow the plaintiffs to pursue the wrongful death action singularly.
That gets us to the next question in our investigation, and it's a basic one. How strong is Karen Read's case? As we move forward here to help with the investigation, Karen Reed's supporter, Nick Rocco, and still here, Massachusetts trial attorney Wayne Dennison. Nick, what's your take here? It's a civil, it's different. The burden of proof is far less than it is in a criminal venue. What do you think is going to take place here?
So that's correct. It is a lower burden of proof, but the issue is the same thing that we saw in the criminal trial. They don't really have evidence that proves that Karen Reed struck John O'Keefe with the vehicle, hence why every single doctor that got on the stand stood up there and said that these injuries to John O'Keefe were not due to a vehicle, and the civil jury is going to hear the same thing. I'm sure they're going to call a lot of the same witnesses, and one thing to add to that is that Judge Beverly Cannoni did not let the defense team during the criminal trial talk about all the evidence and information that they received from outside sources. So I think we're going to see a lot of that in the civil trial that we didn't get to hear during the criminal trial. And I said it during the first trial, I said it during the second, I'm going to say it here. You're not going to get a jury that is going to find Karen Reed at fault for killing John O'Keefe. I don't believe it will ever happen.
Wayne, how strong is Karen's case?
Well, you start with the proposition that you're never going to get a jury. Yes, we're in Plymouth County rather than in Norfolk County, but we're talking about 40 miles apart. You're not going to get a jury that does not know that she's already been acquitted of the underlying crime. So the big difficulty, if you're trying to bring this case on behalf of the O'Keefe family, is that most people start with the presumption that she didn't do it. That said, it's very difficult to determine how he died. And at the conclusion of all of this, the jury's going to be asked to say, is it more likely than not that this woman who was intoxicated, because that is an established fact, hit him and he died in the snow, or is it more likely than not that she never hit him? And that's going to be the fundamental question, and it's going to be a question that's going to persist throughout lots and lots of testimony. And it is going to be another heated trial, and it's going to be a wide-ranging trial because civil trials do not have the same limitations that you have in the cases that are tried in the criminal courts.
Yeah, there was a bit of a bombshell in that first pretrial hearing that was held in this case, and that is that Karen Reed's team articulated that they want to bring claims against up to 10 different people that were in the Albert's house, investigators, we assume Proctor, and they want them to be embedded into this case.
From Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights, conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims would be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We're asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. They collectively conspired to ensure that what happened in the house was not explored and investigated, and instead Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials, for the death of John O'Keefe and is now facing allegations of wrongful death, all stemming from the same claims.
All right, Wayne, that changes everything. Now you're talking about a monster. You're talking about not only 3 defendants, but they're switching it, adding 10 more, going the other way. How is this going to play out? Will the judge bring it all into this one envelope or deny the defense here?
We're going to see a vigorously fought motion to amend in order to bring in these new third-party defendants. The O'Keefe family will say this is a sideshow, that this is the sideshow that she's tried to erect for the entirety of this case. Whether you want to try to get in another 10 people, I think that's a big reach. And quite frankly, I think they'd have been better off if they would have picked their shots, because the breadth of what they are proposing sidetracks this whole trial. And it makes all the sense in the world, if you're defending Karen Read, to sidetrack any activity here away from Karen Read's culpability. But I will be surprised if we will see all of those defendants in this case.
Yeah, it's a huge change. I mean, it drastically changes it, Dick. But if it does, to Wayne's point, it would be huge, because it now becomes, if not a sideshow, a very long novel. Instead of a tight story, you're talking about basically pointing the finger at each one of these 10 people in different fashions, and then having a jury having to decide ultimately if it gets that far. Your thoughts on this strategy by Karen Read's team?
We saw that during the first trial, pretty much. Everybody under the sun was called to the stand, and I personally do think it did get a little confusing, especially if you don't know the ins and outs and the players of this case. When you have all these people getting on the stand and telling a story, if the stories are all over the place, the jury, it's hard for them to keep up. But what I will say is, whether this judge allows these 10 people in places into this as a third party, so if he denies that, they will most likely file suit outside of this case and still proceed to go after those individuals that were named today. But under my understanding, they wanted to lump it all into one instead of down the line filing a motion to then add them in later. So I think what they were trying to do was all at once. But again, it is Plymouth County, so that's different than Norfolk. Yes, it's 40 minutes away, but again, we'll have to see and wait to see what happens. But I think ultimately those lawsuits will get filed one way or another.
Yeah, boy, if it's all in one, get your scorecards out. It's going to be hard to keep track of it, and wouldn't want to be on that jury. Let's get a break. When we come back, does the plaintiff need to prove that Karen Read actually hit John O'Keefe?
Now, back to the Court TV podcast.
I'm Ted Rowlands in for Vinnie Politan. We continue our investigation into the death of John O'Keefe and the civil suit against Karen Read playing out inside a Massachusetts courtroom. The woman acquitted of his murder is now the target of a civil lawsuit. Here is the story. On a cold morning in Canton, Massachusetts, the body of Boston police officer John O'Keefe was found in the snow outside a home. Questions swirled for years, and in the second trial against his girlfriend, university professor Karen Read, the jury returned a not guilty verdict. Read, her attorneys, and the thousands of people across the country who supported her cheered. The acquittal meant the prosecution failed to prove that Read drunkenly backed her SUV into O'Keefe that night, despite a large amount of evidence presented at trial. The defense presented their own evidence, alleging Read couldn't possibly have hit O'Keefe and focusing on missteps in the investigation. Now, the family of John O'Keefe has filed a civil lawsuit looking to hold Reed accountable, bringing the case back into the spotlight and raising the question, will the outcome be any different this time around? So there'll be some similarities, obviously, between the criminal trials, remember there were two of those, and this civil litigation. And one of the questions, ultimately, that the jury is likely going to have to answer is the same question that the criminal juries tried to answer, and that is, did Karen Reed actually hit John O'Keefe with her Lexus SUV? We heard a lot about it. We heard arguments from both sides in the criminal trials. Here's a refresher.
Let's have the car drive into me. I did this at very low speeds, and you'll see, and we'll throw this from two different angles. That's me showing I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2-mile-an-hour impact. But even a 2-mile-an-hour impact redirects me back and causes me to rotate and take a step. So similar to the other test, this is the post-contact image of the transfers onto my arm.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Sure. I can answer.
Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening. With a reasonable degree of scientific certainty, that is what happened.
Do you have an opinion to a reasonable degree of engineering certainty whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes.
What's your opinion?
That it is.
The only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain, into his base of his skull. His injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
Did you determine, based on the testing by aperture, whether or not it was consistent, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight? Has to be.
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts pain on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible.
We had the instrumented hybrid arm outstretched from the test dummy with the accelerometer on the hand and the forearm. We had data acquisition on the vehicle, monitoring the speeds of the vehicle. We accelerated that vehicle into the arm at 24 miles an hour to conduct a dynamic impact test to collect data certainly about the acceleration that the arm experienced, but then also make observations about the damage that we observed to the taillight. So the forearm making contact with the liftgate taillight, and then the upper part of the forearm and the elbow making contact, a direct hit into the quarter panel taillight. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
Do you have an opinion or conclusion as to whether or not the damage that you saw to the hoodie related to John O'Keefe is consistent or inconsistent with a impact from a right rear taillight of the subject SUV?
It was inconsistent.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight?
And that gets us to our next question. In the investigation, seems like a basic one, does the plaintiff need to prove that Karen Reed actually hit John O'Keefe? Here to help answer, longtime Massachusetts attorney Richard Grundy is with us, and still here with us, Margaret McLean, former prosecutor and host of It's a Crime with Margaret McLean. All right, Richard, good to see you. Your take, the answer to this question, does the plaintiff need to get this jury to believe that Karen hit John?
Well, I guess the simple answer is no, but that's for the reason being that they've basically made 2 claims here. The first claim is directly on point with what we're discussing, a negligence death, cause of death, against the bars, 2 bars, and then Karen Reed, brought by the estate. But I think what really attracts my attention to this is the second round of complaints, which is the intentional infliction or reckless infliction of emotional distress. And what this claim is being brought on behalf of his father, his brother, his mother, and Kaylee. And this is saying that this is focusing right in on the trial and the defense, saying that she conjured up this story with respect to the death of John O'Keefe, knowing it not to be true, therefore inflicting emotional distress on this family, which doesn't matter whether she struck him or not, if they can prove that this story was made up with malicious intent and did in fact cause distress on his family. And one thing I'd like to point out is, in my opinion, we're already off on a bad step, because the defense got up there and said, in trying to get this dismissal on Kaylee, that she drove away from the house and started making up a story. In fact, paragraph 39 of the complaint specifically notes Karen Reed waking up Kaylee at 4:30 in the morning before that body has been found, before the snow had started, saying that her uncle, who had taken on a father role, was dead. She's afraid she got hit by a plow. For those of us that watched the criminal trial, we meant that. So if she does that intentionally knowing not to be true, that certainly is going to go to a jury that she intentionally caused emotional distress on young Kaylee.
It basically, that second prong that you brought up was it's about her behavior, and it's about her doing the interviews, her pushing, giving information to Turtle Boy, who then created an army that basically attacked the O'Keefes. And that part of the equation is unique, and it's interesting because we all sort of watched this play out in the way it did. And I guess according to the plaintiff attorney, extreme and outrageous behavior is what they're alleging. And they're saying this is not a case of being rude and clumsy, it's extreme and outrageous. Is that the bar?
Well, it can be intentional, and it can just be, it's one charge. It can be intentional, or it can be reckless and negligent. If you're just throwing it out there, it doesn't have to be, I'm doing this for the intentional purpose of creating this distress. It can be, I'm still drunk and I'm doing it. And it can be just, I got to come up with a defense quickly, which I think is going to be at the root of their argument. But I mean, I really think, when you mentioned Turtle Boy and all that, the building of the monster was never dissected in the criminal trial. And that's what they're talking about doing.
And that's what they're going to try to do. Yeah, here. Margaret, we lost you a little bit, but you're back.
Yep.
What's your take here on this question? Does this jury need to believe that Karen hit John?
Yeah, they have to be able to convince the jury that John's injuries more likely than not, remember, resulted from a motor vehicle strike. But there's plenty of evidence, in my opinion, to support the theory. You've got the debris field from the taillight. You've got O'Keefe's body at 34 Fairview, data from her SUV, the cell phone data, accident reconstruction testimony, as we just saw, her statements, I hit him, I hit him, I hit him. Did I hit him, and the head injuries. And also, in my experience, in this case, we have a sympathy factor going on here because jurors in civil cases, I think, ultimately have a sympathy to grieving families. So I do think it's the fact that it's a much lesser standard is something to really consider. And all that evidence will go back in, and there's quite more likely than not, I think there is quite a bit of evidence that she struck O'Keefe with her SUV.
Yeah,
and this time,
the first
I don't
two
think
juries
they'll have
didn't buy
any.
it. At the end of the day, I get it. It's different. You know, it is a different burden, but we'll see. We'll watch it play out.
Yeah.
Still to come. Richard touched on it. Did Karen Reed cause the O'Keefe's emotional distress? That's next.
I've said from the beginning that I do not want this to go to trial.
This is the Court TV Podcast.
I've said from the beginning that I do not want this to go to trial. Like, this is not my last trip to Canton. I will be back.
How stupid do they think we are? How stupid? They're lying to us. But State Trooper Michael Proctor has abused our trust.
You're saying as you sit here today, you have no awareness in the history of this case that you were being threatened by an online blogger.
I was not threatened by an online blogger. So I messaged Lucky. I introduced myself, and he said he didn't want to talk. So, did you threaten him? Absolutely not.
Lucky, the snowplow driver. Let's get to our last question in our investigation for this hour. And that is, did Karen Reed cause the O'Keefe's emotional distress? Was it her reckless behavior that caused it? Let's bring in our experts. Longtime Massachusetts attorney Richard Grundy is still with us. And joining our conversation, Kim Whalen. She's also known as Nurse Kim on the TikTok and the YouTube. All right, Kim, what's your take? Did Karen Reed, through her behavior, cause the emotional stress to the O'Keefes? That's what's alleged in the civil complaint.
Yeah, unfortunately, I do not believe that Karen Reed did cause the emotional distress and, negligent emotional distress to the O'Keefe family. Her actions were that of a girlfriend who has gone through now 2 trials and has been acquitted in the death of Officer John O'Keefe. I believe that she suffered emotional distress, and I do believe that the O'Keefe family did suffer emotional distress and continue to as they grieve the loss of Officer John O'Keefe. However, I do not believe she was responsible for that in any way, shape, or form, due to the fact she was going through everything in real time in this tragic event, just the same as the O'Keefe family were. And I do not believe she is responsible for their emotional distress in this matter.
Richard, no matter what side you are on this, the O'Keefe family went through the ringer. And did Karen Reed, is she responsible?
Yeah, so that's exactly it. There's no question that there was emotional distress here. You have to be a robot not to experience that in any of these people's situation. So the easiest way there is to focus on, if she, in fact, knowingly caused the death of John and then ventured out into this story. That would be the most direct proof that she is the proximate cause for their distress or a part of it. But again, a jury, as this is presently charged, a jury could find that she was drunk. She said to her father, which we know previously, I think I hit something, I don't know what it was. So she's not assured that she hit him. Perhaps she didn't hit him, but in a drunken tirade, whatever, she goes into this rampage where she decides she's going to defend herself before the accusations come down. And I think, again, if we see these 700 text messages from Turtle Boy, the content of those may change the tide, may make things look differently. But it doesn't, the jury's not going to have to find that she, in fact, hit him and caused his death to cause that emotional stress if there was an effort on her part to put something over on this family that she knew not to be true.
Kim, if you believe that the O'Keefes did suffer emotional stress and it wasn't Karen that caused it, who did?
Well, I believe that the Commonwealth of Massachusetts and that the Norfolk DA's office and Mass State Police have really put on a case that at best was negligent and at worst was potentially nefarious toward Karen Read. So if anyone is to blame, perhaps I would look at the agencies that prosecuted this case not once but twice, and in which they came up with not guilty verdicts, and, that Karen Read has been acquitted of these charges. I know that the preponderance of evidence is different in a civil case, but I don't see how they get there.
Richard, let's say that the jury believes that, yes, okay, Karen went out and she told her story. There's nothing wrong with that. Did she reasonably know that this would take off to the point where it did? And would it be her responsibility to stop it?
Good questions, and those would be decisions for the jury. I would think that, let's say she does not have a legal responsibility to stop it, but it shows that intent to allow the emotional distress to continue on the family. So I wouldn't say she has a legal responsibility to stop it, but it's something that a jury could take into consideration if they feel, again, that she's doing this knowing it to be false and seeing day to day through 2 trials the family suffer through this. I mean, I think for me, the trigger point on this one is the 14-year-old girl and the circumstances where she's being woken up in the middle of the night. This is a girl who Karen Read knew lost both parents at an age where she comprehended that she had lost both parents, being told by a drunken woman in her room at 4 o'clock in the morning that her uncle, who had taken on the father figure, is now gone. That's some infliction of emotional distress if it's being done intentionally, carelessly, or recklessly.
Yeah, and that will be up to, ultimately, if it gets that far, a jury. Thank you both. Appreciate your time as we continue investigating. We're going to have a lot of this moving forward, but that's it for now. I'm Ted Rowlands in for Vinnie Politan. We'll keep digging for answers as this investigation continues, and we've got a long road ahead as the civil case against Karen Read rolls on.
There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.